Hey everyone, I'm Hazel Horvath, founder of Ecolytics, and today I'm joined by Jim Black, who is a legal expert on benefit corporations and someone we're lucky to partner with as we navigate the big shifts happening in the impact business world. So we put together today this conversation about breaking down some of the most common roadblocks that companies are hitting right now, from the legal requirements of being a benefit corp to the new B Corp standards and what it actually takes to do this work well. So we wanted to have this conversation. So whether you're already certified, just getting started, or somewhere in between, we want to make this a helpful discussion about what's changing, what's required, and how companies can move forward with confidence. So thank you so much for joining me, Jim. Would love to just start with if you could introduce yourself and a little bit more about your work at ImpactGC.
Sure. Thanks a lot, Hazel. It's great to be here. I think this is a really important topic and sort of an evergreen topic for B Corps and a lot of mission-driven companies, sort of understanding the importance of being a benefit corporation, what that represents, how you have to kind of act in accordance with that status going forward on an ongoing basis, and not just sort of set and forget. So I'm very happy to have this conversation. Very quickly, I'm co-founder of ImpactGC. We are a mission-driven law firm pending B Corp. Currently, we're about to submit our certification in the next couple of weeks. Very excited about that. We're also a 1% for the Planet member and certified carbon neutral by We Are Neutral. So we are a law firm that is really focused on working with B Corps and other mission-driven companies. We have a good number of B Corp clients. We have an additional good number of benefit corporation clients that are not B Corps or not yet B Corps. And we encourage all of our clients to look at these structures as ways of kind of giving themselves some accountability and some structure and ways of sort of thinking about their own impact and how they can improve their positive impact and from a social and environmental standpoint. And we as a law firm strive to be, to walk the walk as well as talking the talk.
Yeah, that's awesome. So great. And really excited to have you as a partner. Just to give a kind of brief context too about how that works is what my company Ecolytics does is we're a software that helps other companies build data-driven sustainability programs. So we work a lot with B Corps on helping them streamline the certification and recertification process, because our platform is really this end-to-end sustainability program that helps companies measure their impact, improve, and report and showcase it. So between our two companies, we really have that process covered in terms of B Corp and benefit corporation. And I think it's interesting because those two terms often end up getting a little bit confused. I think just from hearing from our customers, sometimes the term B Corp, companies will think about it as an S Corp or a C Corp, but really there's a delineation between benefit corporations and the B Corp certification. And I was wondering if you could speak on that a little bit more, and if you hear that too from the companies you all are working with.
Yeah, absolutely. It's really interesting that there's, a lot of people seem to think that B Corp is short for benefit corporation, or they have a lot of confusion around what are the two different terms mean? What does benefit corporation mean versus B Corp? Is it the same thing? In a lot of cases, it is the same thing in the sense that B Corps are typically also benefit corporations, but they are very different in how you get there and what they represent. And so, as you know, Hazel, the B Corp status is a private certification managed by B Lab of a company's impact across all different areas of its operations, and how it functions as a member of society and within the world. Benefit corporation status is actually a legal status, right? And so when you form your company, or if you have a company, you can convert your company to a benefit corporation. That's actually a separate legal statute in most states now. Something like 42 states plus the District of Columbia have benefit corporation statutes. And so if you're forming a new company, you would form it under the benefit corporation provisions of that state statute, as opposed to the traditional corporate provisions. A lot of those traditional provisions still apply to benefit corporations, but there are some distinguishing characteristics of benefit corporations. And one of them at a very superficial level is that you typically have to have BC, PBC for public benefit corporation or benefit corporation or something like that in the name of the company. So it really indicates to third parties, this is not a traditional corporation, it is a benefit corporation. But there are plenty of companies that are benefit corporations that are not B Corps. There's no requirement that if you are a benefit corporation, you have to be a B Corp. Conversely, there is a requirement if you're a B Corp, at least in the US, that you are a benefit corporation if that status is available in the state where you're incorporated. And if not, then you have to add some language to your charter to kind of reflect the same principles.
Yeah. So I'm interested in digging a little bit more into that specific piece too, because we sometimes get companies that we can help streamline the process of B Corp and that whole certification process, but we are not a law firm and we can't help companies through that legal incorporation or reincorporation process. So sometimes we have companies come to us that really want to be B Corps, but then maybe their legal teams are a little bit hesitant or their leadership is a little bit hesitant about going through any sort of legal process, because sometimes that can be, the unknown can seem a little bit daunting if, they're thinking about that, and thinking about reincorporation might seem like a much bigger process. And so I'm curious if you could shed a little bit more light on what that process actually looks like for companies that are pursuing B Corp certification and then realize that they need the legal designation as well.
Yeah, happy to. And it's interesting because I get approached from time to time by companies that are interested in doing a B Corp certification. And my first answer to them is, I'd love to connect you with somebody who can help you with the B Corp certification, right? What I can help with as a lawyer is the benefit corporation side of things. That is, as you mentioned, the so-called legal requirement for becoming a B Corp. Everything beyond that is not a legal process, right? And I think people sort of confuse the two at times and think that becoming a B Corp is primarily a legal process. It's really not. The only legal part, strictly speaking, is the benefit corporation conversion. And so, if you have a company and it's currently a traditional corporation, and it doesn't matter whether it's a C Corp or an S Corp, it also doesn't really matter if it's an LLC or something else. The process is very simple to convert into a benefit corporation, and that really just entails an amendment to the Articles of Incorporation or Certificate of Incorporation, and that amendment typically is something that has to be subjected to a shareholder vote. Many of the companies that I see and speak with are small, and they have a small number of shareholders. So it's not too hard to get the however many shareholders you have to consent to the conversion. And then it's really just a matter of submitting your amended articles to the state of incorporation. And it's a very quick and easy process. The main thing that's required for it is consensus among the shareholders that they want to do this, right? And so as with kind of B Corp certification in general, I think the first thing that people have to do is build that consensus within their company. And once there's commitment and there's buy-in from all the shareholders and, from the entire executive team, then I think you're ready to go down the road. But then once you do have that consensus, the legal part is very, very simple and quick.
Yeah, definitely. And then one thing we've also talked about before too is the impact reporting and benefit reporting piece of that. And I think that's a big area where we can also maybe clear up some misconceptions as well. Because we help companies have an impact report that meets both the benefit reporting requirements and is also a tool that helps companies with the transparency requirements for B Corp, which is becoming even more important with the new standards. And I'm sure we can talk about that later. But you were sharing with me some interesting statistics around those compliance pieces to those reports. And I'd love to chat a little bit more about that.
Yeah, it's very interesting. So when you become a benefit corporation, you're doing a couple different things, or you're agreeing to do a couple different things. One is you're agreeing to put language into your charter, your articles of incorporation, that state a public benefit that you're aiming to achieve through your operations. And that can be either a general public benefit, Or it can be also a very specific one that is specific to your company, whether it's eradicating homelessness or supporting veterans in your community, or it's working for environmental justice, or there's a myriad things that you can target as your specific benefit. And so that's part of what you're doing, is you're identifying what is the purpose of your company, beyond generating a profit for shareholders, right? And these are all for-profit companies, so profit for shareholders is part of it, right? It's not eliminating that as part of the corporate purpose, but it's adding additional factors that you'll take into account going forward. Another thing that you're signing up for is benefit reporting, as you mentioned, and what that means is it depends on the state. Different states have different statutes on this, or different provisions relating to the benefit reporting. But typically, you either have to report annually or biannually on your efforts to achieve the public benefit that you set out to achieve, and your success in doing that. And there are differences in the state statutes in terms of what you have to report, what detail you have to report, and also how you have to measure that progress. And so in some states, the ones that follow the Model Act, typically you have to measure your progress against a third-party standard. And that can be the B Corp standards, right? It can be the impact assessment that you do every year to measure how you're doing. It can be some other third-party standard that you have kind of assessed and determined to be appropriate for measuring your impact. And then you have to report on how you've applied that and how successful you've been in achieving your purpose. In Delaware, you don't have to use a third-party standard, but it's still your method of assessing your own progress has to be well-founded and reasonable. So it does differ from state to state, but typically then you have to either provide your benefit report to your shareholders at a minimum, or in many states you have to publish it on your website. And this is a very kind of basic requirement of transparency and accountability for benefit corporations, because part of the reason for these statutes is to fight purpose washing and greenwashing, right? It's to establish legal mechanisms so that when people see that a company is making claims that they work in the public interest, or that they are trying to achieve a public good, that there's actually something behind that. And it's not just words on a page, right? And so this benefit reporting is actually a very key element of that, because it gives people the ability to have some transparency into what the company's actually doing, how successful it's been in generating that public benefit. And so it's a really important part of the whole regime that public benefit corporation statutes are meant to create. The problem is twofold. One is that many public benefit corporations or benefit corporations around the country don't seem to actually comply with this requirement. So based on some research that I was looking at recently, the vast majority of benefit corporations don't even publish their annual benefit report as they're required to. And the second part of the problem is that most states don't devote any resources to enforcing that requirement. And so you really have a situation where there are many companies out there that have this benefit corporation status and may use that in marketing or in kind of, building relationships with business partners, but they're not actually fulfilling the core transparency and accountability requirements of the status. And there are, based on what I've read, only a couple states that actually try to enforce that requirement of publication. And so, we have a status that in principle is very meaningful. And if it's fully complied with, I think is meaningful. It really does create a model for a different type of capitalism, which is really what we're trying to achieve here. But because of the very pervasive noncompliance, I think it's being watered down. And so I think it's a real challenge for the mission-driven business community, for the B Corp community, to try to be very assiduous in complying with these requirements.
I completely agree. And especially in terms of that purpose washing or greenwashing that you mentioned, that companies, become a public benefit corporation because they intend to be a profitable company, and then also pair that profit with a very impactful purpose. And so while they may set that as their mission, if they're not creating some way to hold themselves accountable to that, to track or even measure any progress on that, you do run the risk of that happening for your company, that even if it's not intentional, and I think that's most of it is not intentional, in terms of making claims that you can't back up. And so the legislation, as you said, does a great job of building that in, the need for a third-party standard. And that, I think, since the benefit corporation legislation and B Corp end up being able to be, or at least the benefit corporation legislation is able to be applied separately from the B Corp standard, I think that could be a little bit of a point of confusion of what is that third-party standard means. Yeah. But B Corps can know that if you are going through the certification process, you're meeting that third-party standard requirement if you're building as a B Corp. And then the legislation leaves open that optionality for additional standards if B Corp isn't that end goal for your company, which is interesting as well.
Yeah, I think that's right. They are sort of mutually reinforcing structures, right? So the benefit corporation status supports your ability to become and remain a B Corp, and the B Corp assessment process and the rigor of that supports your sort of assessing your performance and your progress. The other thing that's interesting is many of the statutes, not all of them, Delaware does not include this, but many of the benefit corporation statutes include an express mechanism for shareholders to bring so-called benefit enforcement proceedings, which is basically a derivative action on behalf of the company brought by a shareholder that would basically be making the argument that the company's not doing enough to pursue its public benefit, or it's not achieving enough of a positive impact. And even though that sounds like a very forceful mechanism, and in principle it is, to my knowledge, there's not a single reported case across the US of a benefit enforcement proceeding having been brought and heard by a court and ruled on. And so it's an interesting kind of situation. We have these statutes that have some really potentially powerful provisions in them for accountability and for enforcement, and yet they're not yet working the way they were intended to. I would wager that, of those companies that are benefit corporations that are complying with the statutes and are issuing their benefit reports, and they are in compliance with the requirements, most of those are probably B Corps, right? Because they know that they are subjecting themselves to an outside examination every 3 years, where they're going to have to say, yeah, not only am I a B Corp, but I'm complying with my obligation, and not only am I a benefit corporation, but I'm complying with my requirements as a benefit corporation as well.
Yeah, definitely. And that also points to something we were talking about earlier as well, is B Corps will publish big annual impact reports for meeting that transparency requirement for B Corp and the actual standards. They're on the previous or the current version 6 of the standards that companies can certify under until the end of the year. There's a transparency requirement. And then in these new standards, there are a number of transparency and disclosure requirements that are now built in that need to be on public facing web pages for the company to comply with the new standards. And just to give a tidbit of additional context too about the new standards is that since they are binary, so companies either have to meet them, or if they don't meet them, they're not able to become certified or recertified. That makes having that level of transparency and accountability, publishing these documents and reports, even more important. And so with annual impact reporting, as I think sometimes we commonly see it, they will be great, beautiful impact reports filled with data and storytelling and awesome examples of work that companies are doing, but sometimes they're falling short of these actual compliance requirements. So I'd love for you to dig a little bit more into the details, since that's definitely more in your purview, but that to kind of share what you've seen in that space as well.
Yeah, it's really interesting. As you said, there are some companies that do an amazing job of reporting, and they produce really detailed, very useful information about the impact that they're having across all different stakeholder groups. Some of those reports, however, don't take or incorporate in that process is not also a process of looking at the statute in their state and seeing what specific disclosures do I have to have in here? What do I have to specifically state in my benefit report in order to comply with the statute? And so some states require you to, or they give you the ability to appoint a benefit director or a benefit officer, for example. And that person, if you have appointed that person, then they have the obligation to certify the report essentially. If you don't have a benefit director or officer in those states, you have to say so. And there are other sort of disclosures about what is this third-party standard that you're using? How did you select that? Why was that determined to be sufficient for measuring your progress and your impact? And a lot of the benefit reports that I've seen talk a lot about the impact, and they describe the third-party standard, but they don't talk about the process that the board went through to decide this is the right standard for us. This is why it is, adequately rigorous or appropriately rigorous, and why it's the right standard for our company, because there may be different standards that are appropriate for different companies depending upon their size, their industry, et cetera. So sometimes you do see these wonderful reports that are very informative, but they actually don't meet the statute in all respects. And again, the states don't seem to be very active in enforcing those statutory requirements.
So I think something that's come up recently, especially in terms of the new standards, as well as this current moment in 2025 with the new presidential administration and a lot of change happening in our world, and as well as in the B Corp community too. And so B Lab has put out these new standards that are raising the bar for what it means to be a purpose-driven business. And it's been really great to see companies in this current environment, especially B Corps, really see the certification as a module of standing up for their beliefs. That I've been hearing from business leaders that B Corp allows them to really show what they believe in terms of their business. And that's kind of the beauty of being a private business, is your leadership can decide what values make sense for your business. And I think we're really also seeing employees notice that as well, that work for B Corps, that when they see the values that they believe in reflected in their leadership and built into the company, I think that's a really powerful statement and tool that we've been seeing companies use in the current environment. And so I'm curious to, from your perspective, in terms of legal, their benefits or obligations for companies in the context of the new standards and where we're at in this moment, if there is any kind of advice or guidance for companies to maintain that independence.
Yeah, it's a really challenging time, obviously, for a lot of companies. And a lot of, we talk to a lot of companies that are very concerned about, not becoming a target of some sort of legal enforcement, whether it's justified or unjustified, based on their approach to their business, whether that's, having DEI policies or programs or environmental goals or other things like that. And so, we hear a lot from our clients. There's a lot of stress around their public facing communications. And, as you're saying, there's a lot of positive value from companies showing that they do have these values, that they do have this very specific approach to business that is stakeholder focused and not shareholder focused, in terms of attracting and retaining employees, attracting and retaining business partners and customers. And so I think it's a really hard moment for people to balance how much to say and how to say it, with not wanting to put themselves in the crosshairs of some prosecutor who's going to try to make a name for himself. And so we've had a lot of conversations around reframing and, deciding what was not performative in the negative sense, but what was sort of a way of framing a company's policies or approaches to hiring, to dealing with the environment or with their employees, with communities, with other stakeholders. how can you boil that down to its essence of what's truly important, what they're actually doing, and not get so caught up in what words you're using to describe that, but try to be more sort of qualitative and, avoid, if possible, the sort of buzzwords that seem to set off alarm bells with a lot of government actors right now, and private actors as well. And so we have had a lot of conversations around that. From a legal perspective, you know, the thing that's a bit of a conundrum is DEI programs, generally speaking, exist in order to help companies comply with their obligations under civil rights laws to not discriminate, right? So DEI programs in most cases are designed as a tool to ensure compliance with non-discrimination requirements under the civil rights laws. They're now being portrayed by this administration as a violation of those civil rights laws, which is really turning everything on its head and, in my view, nonsensical. But what you're seeing is companies asking us the question, well, how do we continue to make sure that we are complying with our obligations under the ADA or the Civil Rights Act of 1964 or other things like that without getting in the crosshairs of this administration? And, it really is, to me, a question of continuing to do the work and continuing to have your policies, implement your policies, but just be very thoughtful about what you're communicating publicly and how you're characterizing them. And, I think it is kind of a very difficult time for companies to navigate that, but it is still possible to be very thoughtful and to be very active in pursuing a diverse workforce and an equitable workforce and an approach to your business and to your stakeholders that is just and equitable. You just have to be thoughtful about how you're communicating about that.
Totally. Yeah. And I think that it's interesting because with B Corp, the whole model of the standards have us build our businesses for our stakeholders. Instead of the shareholder model, it's moving towards that stakeholder model. And so in thinking about the communications and dealing with the current political environment, I think it's also important to think about your own specific company stakeholders. Where does that look like for you? Because for some companies that are selling into the government and are going after those contracts, the government is a big stakeholder in that. But for a lot of private businesses, the government is, on the fringe of, relation to their business. And so what's really important for them, that bigger stakeholder group, is going to be their customers, their employees, and those are their community. Those are the stakeholders that are really going to be paying attention to how you react to the administration. And so I think staying true to your values, especially as B Corps, and continuing that process and movement is even more important, because those bigger stakeholder groups are going to be the ones that are paying attention for a lot of businesses, not all, but much more than the federal government.
Yeah, to follow up on that, that's a really important point. So there are companies that depend on government contracting for a significant portion of their business, or whose clients depend on government contracting, and so they're one step removed, but still, affected by the things that the government is doing. And it is, the government has taken steps to force companies that are contractors, direct contractors, even indirect contractors, to stop pursuing their DEI goals and to stop having these sorts of programs and policies and communications. And that's something that those companies in particular, have to navigate in a much more careful way, I would say, than companies that really just do business with private customers and suppliers. It really is, despite all the noise, it's hard for me to imagine how the government could successfully come after a company that's not a government contractor, and it is simply, a private actor in the economy, and chooses to do its business in a certain way. And one thing that I've talked to some clients about is, if you don't want to have your DEI policies or ESG policies just sort of be policies of the company, you can embed them in your contracts too, right? Where you are committing to your contract counterparties, whether it's your customers or your suppliers, that you are complying with certain standards. And it's very hard to imagine the government successfully challenging a privately agreed contractual relationship and commitment, right? And so that moves it beyond just policy, where you have, a decision that this is how we're going to do business, and it moves it into the realm of an enforceable contractual commitment. And that may be a way for companies to kind of defend their policies in these areas, to say, this is not just us choosing to do business this way, this is an enforceable contractual commitment we have to all of our suppliers, all of our vendors, et cetera.
Yeah, and I think it also leads back to the business and the ROI of B Corp and sustainability, in that it's interesting to see this policy and the government going after these certain aspects of business that ends up being a business driver for these companies. So in some way, you can make the argument that they're kind of handicapping certain revenue streams or certain opportunities for greater business if they go after certain impact-driven aspects of companies. Because that's what we always get back to in terms of B Corp and implementing sustainability at a company is companies are doing this because they believe in the broader movement, but also that it will grow their business by implementing B Corp principles.
Yeah, absolutely. And that's one of the kind of perverse aspects of this, that, this is free enterprise, right? This is nothing other than free enterprise. This is individual businesses and business owners and leaders deciding that this is the optimal way to run their business for business success. And yes, there's a social element to that, there's an environmental element to that, but this is, for most B Corps, in my experience, a business-based decision, right? That this is the best way to run their business. This is the pathway to success for them, to commercial success for them. And to have the government tell you that you shouldn't be doing that is, especially a government that claims to be all about unfettered capitalism, it's a very odd situation.
Definitely. Yes. Seems a little contradictory.
Yes, exactly.
Yeah. And so I think that also gets a bit into the new B Corp standards. And I think it could be interesting to chat a little bit about how the two pieces of B Corp that we talked about, both of us work on, so you on the legal side, us on the certification side of things, with the new standards, how that will update both of those aspects. And I think curious first to hear from the legal perspective, if there is anything that companies need to know in implementing the new standards.
So I'm not aware of any substantial change to the legal requirement. As far as I know, you'll continue to have the requirement to be a benefit corporation if that's available in your jurisdiction, or otherwise to incorporate language in your organizational documents. I'll be interested to know. I think we're all in the exploratory phase with the new standards, and we haven't really been through a cycle of companies certifying under them or getting feedback from B Lab, or from the independent agencies that are going to support the process now, on how the standards are going to be really interpreted in practice. So I'll be interested to see if there is any evolution of that legal requirement part, which up to this point has been pretty straightforward and easy to meet in a lot of ways. But as I said, I'm not aware of anything that fundamentally changes that aspect of the requirements.
Yeah, definitely. And in terms of the certification side of things, I think that's the big overhaul of the change, in that in previous iterations of the standards, they would call them version 5, version 6, but now B Lab is saying these are new standards. We're really changing the model and pushing companies to continuously improve through these new standards. So I think that would be a whole other conversation that we could have about all the changes. But I just will plug that that's obviously something that we're helping through our company, helping companies transition, since this is going to require a fair amount of upskilling from companies. And B Lab is putting out some great resources, and we're also doing the same to just help companies better understand what really applies to them. Because on the previous standards, like I said before, previous standards were on a point system, and now they're binary. So companies have to meet all the standards that are relevant for their company, and there's continuous improvements mechanisms baked into them. But I think companies will find that the previous assessment, all companies of different sizes, while they were tailored a little bit by sector, there was this 200 question assessment that they had to fill out to be able to become certified. And now under the new standards, the questions or the sub requirements are more tailored to the actual company size, the company sector. And so I think that will be a great new way to do the standards, because I think often companies felt that some pieces of the old assessment weren't as relevant to them, whereas this will be very tailored, and then also raising the bar and helping companies really implement sustainability. So it's not on a, let's look at B Corp every 2 years or so, but now it's something that companies really are keeping up with and getting that value out of.
Yeah. And I think consistent with that drive for continuous improvement, I think whether it's strictly required or not, I think it's a good moment for B Corps to look at how they're approaching the benefit corporation side of their kind of managing their business and communicating. Because, I suspect, as with many legal requirements, it's viewed as sort of an admin task of, okay, we have to do this to fulfill this requirement, but it's not necessarily viewed as a really important tool for management to use to sort of monitor their own progress and their own their own impact. And I think that ideally the way the benefit corporation statutes would work in practice is that they would be a very useful tool for companies to sort of in a very detailed way monitor what they're doing, assess what they're doing, reassess what they're doing, and every time not just try to, as in the past, score more on the impact assessment under the old system every 3 years, but really look at how are we implementing the principles of being a benefit corporation in our company. How is that infused throughout what we do, how we make decisions, and particularly for board members to really place that front and center as they're meeting, monthly, quarterly, ad hoc, whatever it is, and always putting those in front of themselves and saying, let's remind ourselves, this is the purpose for this company, right? So let's take this purpose, this broader purpose, this broader lens we're supposed to take to our decision making, and let's be very purposeful and very intentional about applying that to all these decisions we're making today, right? And I suspect that that's not done universally. And board members probably make decisions based on, yeah, that makes sense for the business, let's do it, right? Whereas I think that ideally the way the benefit corporation statutes and status work is they would bring an additional layer of rigor to decision making, where that public benefit is always front and center in every decision that you're making, and you would also document that, right? And the fact that these enforcement mechanisms that I mentioned are not actually being used effectively shouldn't prevent companies from being very active in trying to live the ideal of what a benefit corporation should be.
Yeah, and that's a great example of the updates to the new standards, that there's a sub-requirement in the purpose and stakeholder governance section that requires companies to periodically update their highest level of leadership on their social and environmental performance. So that's something that at Ecolytics, we're very focused on, because our platform allows companies to automatically and continuously track their impact. That information is always ready for your team. So you can really use it to make decisions and have it in those board meetings and those conversations, because it's always ready to go, versus since the process can be so manual in that data collection and getting everything together on what your company has been doing. I mean, that in itself can take months. So the preparation for that to then go into a regular meeting about it, can be really difficult. And so that's just one way that we're working to help companies meet the requirements.
Yeah, that makes a lot of sense. And one thing that companies could consider, as I mentioned, a lot of the statutes allow you to appoint a benefit director. And that's also a tool that's actually really useful, because it gives one board member the specific mandate of having that public benefit and having that purpose that's stated in the articles be sort of a core driver of their analysis of any decision making at the board level. And so they would presumably then kind of bring that into the discussion at all times, because they know at the end of the year they're going to have to certify that the company was managed in accordance with that that stated public benefit. So I think it's actually a really useful tool for companies that do have, you know, a number of directors on their board. Some only have 1 or 2 directors. If they're small, may not make much difference. But for a company that has 3 or 4 or 5 or more directors, it could be a really useful tool to do that.
Definitely. Yeah.